Good afternoon. Good afternoon and welcome to our faculty, staff, students, alumni, and friends. I'm William McGevern. I'm the Dean of the University of Minnesota Law School. And of course, we're gathered here for the investiture of Myron Orfield as Professor of Law, as the Earl R. Larson Professor of Civil Rights and Civil Liberties Law. Myron is a professor here and the director of the Institute on Metropolitan Opportunity. At the conclusion of the lecture, I hope you will join us upstairs. You go up one level, go down back towards the elevator, go up one level to our back commons for a reception with light refreshments. I know you're as excited as I am today to celebrate Myron, honor this professorship, and hear from him. An investiture of a named professorship is an opportunity for us to celebrate our incredible intellectual community here at Minnesota Law and to honor faculty members who are its beating heart. And with this prestigious professorship, Professor Orfield joins a community of incredible teachers and scholars. The title of Earl R. Larson Professor of Civil Rights and Civil Liberties Law has previously been held by Professors Susanna Sherry, John A. Powell, and Dale Carpenter. So Myron has large shoes to fill. The Earl R. Larson Professorship in Civil Rights and Civil Liberties Law was created in 1989 with a generous gift from the Honorable Earl Larson. It is intended, to quote, to enrich and expand teaching, research, and scholarship. Today, Myron joins that august company, except as you may know, he was actually appointed to this professorship in 2016. So we're a bit delayed. But it's always a good time to celebrate our scholarly community here at Minnesota Law, and we don't have to worry in suspense whether he will live up to the reputation of this professorship. He already has. Judge Larson was a 1935 graduate of Minnesota Law and was a longtime leader and advocate in this community for civil rights and civil liberties. During his early career, he served in the United States Navy and with the U.S. Department of Justice and the U.S. Attorney for the District of Minnesota office. He was also the founder and first president of the Minnesota Civil Liberties Union and served as chair of the Minnesota Human Rights Commission. In 1961, President John F. Kennedy appointed Larson to the U.S. District Court for the District of Minnesota, where he served from his passing in 2001. In 1971, Judge Larson ruled that Minneapolis schools had to be desegregated and that Minnesota's state mental institutions must improve care of their patients. We are so grateful to the memory of Judge Larson for his generosity and his investment in the law school and in his commitment to civil rights and civil liberties work here and around the country. Now, 36 years after he first endowed it, this professorship continues that legacy of his work on issues that are every bit as pressing today as they were during Judge Larson's lifetime. And now it is my pleasure to formally install my friend and terrific colleague, Myron Orfield, Professor of Law and Director of the Institute on Metropolitan Opportunity, as the Earl R. Larson Professor of Civil Rights and Civil Liberties Law. Congratulations, Myron. Professor Orfield joined the law school in 2003 and was promoted to Professor of Law in 2009. As I mentioned, he's the director of the Institute on Metropolitan Opportunity, which investigates the ways that laws, policies, and practices affect development patterns in U.S. metropolitan regions, with a particular focus on the growing social and economic disparities within these areas. He writes and teaches in the areas of region planning, state and local government law, spatial inequality, fair housing, school desegregation, charter schools, state and local taxation and finance, and land use law. And I should have written a breadth in that list because that was a long one, and there's wonderful work in all of those areas. Prior to joining the law school, Professor Orfield worked in many areas of government and in private practice, and he was elected to both the Minnesota House of Representatives and the Minnesota Senate. In the state legislature, he was the architect of a series of important changes in land use, fair housing, and school and local government aid programs. He served on the National Commission on Fair Housing and Equal Opportunity, and as a special consultant to HUD's Office of Fair Housing and Equal Opportunity during the Obama administration. While there, he assisted in the development of the Fair Housing Act's discriminatory effects standard and the affirmatively furthering fair housing rule. Professor Orfield has a JD from the University of Chicago. His work has led to legislative, administrative, and doctrinal reforms at the federal level and at the state level, not only in Minnesota, but also in Illinois, Michigan, California, and many other states. We are so lucky to have Myron here at Minnesota Law and here in our community in the Twin Cities. Now, as some of you know, we typically present a gift during the investiture. Myron, come on up.
Thank you.
I hope you'll accept these bookends.
Oh, thank you very much.
Engraved with your name.
Oh, thank you. That'd be nice.
Look up to Tony there. Hello. And
Thank you.
if you put those bookends very far apart, they might be able to hold up all of the writing that you've done in your time here at Minnesota Law.
Well said.
So, friends, faculty, students, and everyone here, please join me in congratulating Myron Orfield once again.
Thank you.
And now, before we hear from Myron, please join me in welcoming Reverend Alfred Babington Johnson, who is the founder, president, and CEO of the Stair Step Foundation, and a living embodiment of some of the ways that Myron is connected to so much in our community. Professor Orfield has invited him to join us here for some brief remarks. Reverend?
Thank you. Thank you, Dean. Good afternoon. I'm more than grateful to be here with my friend, Professor Orfield. I am, as has been indicated, the founder of something called the Stair Step Initiative. I founded it in 1992. And the Stair Step Initiative is in place to address what I think is the most critical issue of our times, and that is the breakdown of community. We define community as the way people behave when they believe they belong together. It makes a difference in how we relate to one another, with our accountabilities, with our aspirations. Everything about it changes when we really start to see ourselves not as other, but as brother. And so how do you get that done? And let me just say that the breakdown of community is devastating to the entire society, but even more so to the more vulnerable aspects of the society. Those areas suffer the greatest harm, the greatest difficulty. And we do consider this a providential journey. And we feel blessed that since 1992, we've been in pursuit of this from a blank sheet of paper, and the Lord has brought this forward. And in that regard, from time to time, he introduces you to fellow travelers, to those whose life and whose intentionality is consistent with the real goal. Briefly, let me just say, I was born before the Brown versus Board of Education decision in '54, and managed to join with others in churches across the country as we heard about the Montgomery bus boycott in '55, and sought to gather resources to send to help to advance the cause. And we certainly were watching as Martin Luther King emerged and all the wonderful heroes, African Americans in this struggle. But there was a Pastor James Reeb who died in the cause. There was a Viola Liuzzo who died in the cause. Shirley, Cheney, and Goodman, two of the three were not black. So there were heroes in that struggle that were not sepia of hue. And I feel as if the Lord allowed me to meet another one as we engage with Myron Orfield, who is so dedicated. You know, there's sometimes people say, I can't hear what you say for seeing what you do. There's an inconsistency with what you say and how you behave. That's not the case with Myron. Myron is dedicated to the issue of civil rights. I think, and I'm going to leave you alone in a very few minutes, but I believe the United States is a good idea. I think it's a great idea. I think it's a wonderful idea that all men are created equal, that they were endowed by their Creator with certain inalienable rights, life, liberty, the pursuit of happiness. I think that's a great idea that we're trying to find our way to. And it involves intentionality. Myron, from the moment I met him, demonstrated he's dedicated to that proposition. Not just the words, but the truth. I'm delighted, my brother, to be here with you as you receive this well-deserved acknowledgement and honor. Keep stepping.
Thank you very much. Thank you very much. I think I've got my microphone on. I really appreciate the very warm introduction by the dean and by my friend Babington. And I'd like to thank my sons are here today, William and Sam, and my friend Susan King is here. My sister may be here, but if she is not, I understand. I wanted to thank all of you for coming. I see many former students and many people that I worked with in government. It's nice to see all of you. Today we are in the middle of a very turbulent time in our country, perhaps as turbulent as we have experienced. And I think that some of this turbulence, at least a part of this turbulence, is the fact that we as a society have never dealt with the long legacy of racial segregation, either in the United States or in the Twin Cities. Racial segregation persists at levels, and it really hasn't changed at all in 30 years. In the Twin Cities, it's gotten a lot worse. Part of the polarization in our country is a symptom of us not knowing one another, of people not knowing one another, not seeing one another, not understanding one another. And I'm going to show some maps today about this. A lot of people have seen my maps, but I think it's true. And I think that the Twin Cities was once a very racially integrated place, and it has today still the best fair housing laws and the best land use planning laws in the United States. It's been a long time since they have been used as vigorously as they could be. There are two cases I'm going to talk today about that are challenging the segregated status quo in the Twin Cities. One is Cruz Guzman versus the state of Minnesota, it's about school desegregation. Another is Stair Step versus state of Minnesota. Reverend Babington is one of the plaintiffs in that case, and his organization represents about 150 Black churches in the Twin Cities and a broad variety of Black and multiracial organizations. They are plaintiff in that case about fair housing. These cases, I am a consultant in both of these cases. I'm not a paid consultant, but I'm a consultant in these cases, hoping that they will achieve their goals. So I have to disclose that. I also, before I go on, I'm saying I'm representing my position, not the University of Minnesota's position in any way. And in fact, there are many scholars at the University of Minnesota who disagree with many of the things I say. I'm representing my position alone, and no one else is a scholar. I want to talk about the Twin Cities and how things have changed. This is a graph that shows the percentage of schools that are made of more than 90% non-white students. And the comparison that I'm drawing here is I have Portland, Oregon, Seattle, Washington, and the Twin Cities. And the reason I'm picking those three is they're a lot alike. They're very similar in the percentage of Black people and Latino people that live there and students. They're very similar in the percentage of diversity. Portland is a tiny bit less diverse, but very close. Seattle's a little bit more diverse, but they're very close. And we have similar laws in many ways. We have similar land use laws. We all have fair share housing laws that are very similar. We all have bounded urban growth, which not many places have, but the Twin Cities has that, Portland has that, Seattle has that. We all have a political makeup from election to election that seems quite a bit alike. Our partisan balance seems quite a bit alike. This is the number of percentage of students that are more than 90% non-white and poor. Portland had in 2001 school, it got up to 4. By 2010, it's back to 1 school. Seattle, which has 57,000 more students than we, had 21 to 27 to 40 schools that are more than 90% non-white and poor. The Twin Cities, which didn't have a single segregated school in 1991, had 49 schools that were more than 90% non-white and poor in 2000, 126 in 2010, and 182 in 2020. So it's very different. It's dramatically more segregated than our racial counterparts. Much, much worse. 6 times worse, 7 times worse. Why is that? Why are we so much more segregated in other places? Because of legal decisions we made in the late 90s and 2000s. Legal decisions that had big consequences. And I'm going to talk about these. Now, these cases, Stairstep and Cruz Guzman, are being brought under the Minnesota Constitution. They're not being brought under federal constitution. So they're trying to understand and develop law under a state constitution, in part because the federal courts have been withdrawing in this area, have been moving away in this area. And the idea here is, can these state constitutions and can these state laws fill a gap for states that wish to be more proactive in terms of civil rights than the federal government allows? These are open questions. These are questions that are not fully resolved, but I think the answer is yes. So this is a map that shows us. Now this is a picture of where these schools are. And you see all those red dots are schools that are more than 90% non-white and poor. So you can see they're mostly in the central cities, but they're also in the first and second ring suburbs. And this is a map of the charter schools that are more than 90% non-white and poor. So of these hyper-segregated schools, about 96 of the 181 are charter schools. So you get a feel for the difference there. Here's a picture of the region a little bit. So this is a map. You can see Minneapolis and St. Paul. My students know these maps so well, because they've seen them 100 times. But this is Minneapolis, St. Paul, and the 49 school districts that surround the Twin Cities metropolitan area. And the contour that's red are the areas where the schools are more than 50% non-white, and the areas where the schools are majority non-white. The areas that are blue are between 30 and 50%. So the areas that are red are predominantly non-white. The areas that are blue are integrated. This is 1995, kind of the effective year when we abandoned our school integration program. That's 95. Here's 2005. Here's 2015. Here's 2020. So you can see this expanse of segregation has encompassed a lot of the older suburbs. First 2-3 rings to the north, 2-3 rings to the south. It isn't just a central city issue. It doesn't just stop at the central city border. In fact, as segregation crosses city-suburban lines, it picks up speed and becomes more intense. Central cities sometimes gentrify, sometimes redevelop. Older post-rural suburbs, poverty tends to stick there. It gets deeper. They don't redevelop. So you get a feel for the change. And you can see the red area is the area where segregation grew. The blue area is where integration grew. Now in that blue area, that's kind of a hopeful picture. That blue area is the integrated part of the country. And that is much bigger than it used to be. And this is where almost all the college-bound Black and Latino kids in the Twin Cities are coming from, those school districts in the blue area, almost all of them. So I'm going to talk a little bit about segregation. One of the things I think that people think about segregation, and this is certainly true of lawyers, is there's what we call in the legal field de facto segregation and de jure segregation. As my professor used to say, de jure segregation. And the idea is that one is caused by bad behavior and one is blameless. So there's one kind of segregation that's blameless. Justice Potter Stewart said, in his Millikan dissent, he said, residential segregation that's caused by unknown and unknowable causes, he says. And that's quoted an awful lot. That picks up a lot of chain citations. Many scholars in some of the university say that segregation is mostly caused by choices. But most social scientists, the vast majority of social scientists, believe that racial segregation is caused by at least 6 forms of illegal discrimination that are constant, present, and measurable. So segregation, for most social scientists don't believe there's anything called de facto segregation. They don't believe it exists. Some do, but very few. And what are these forms? There's 3 public forms of discrimination that are constant, vigilant, and everlasting, and there's 3 private forms. So in the public sphere, we built almost all the affordable housing in poor neighborhoods. Virtually all of it are in the footprint of the poorest schools. Now, since the 1968 Fair Housing Act, and since the decisions and the rules that were created by the 1968 Fair Housing Act, that's illegal. There's a case called Shannon versus HUD that said it's presumptively illegal to continue to build all this housing in poor neighborhoods. You have to at least try to be integrated. NAACP versus Boston says the same thing. Justice Breyer, writing as a First Circuit judge, says HUD has an obligation to use its immense authority to integrate the society. The whole Fair Housing Act is about this, is about causing integration. We build all the affordable housing in poor neighborhoods. Exclusionary zoning. That is illegal presently, at this moment, today, under the Federal Fair Housing Act. That's illegal. And in many states, it's illegal under the state constitutions. 6 states, as a matter of constitutional law, their general welfare clause forbid exclusionary zoning, and another 15 states by statute forbid exclusionary zoning, and under the Federal Fair Housing Act is now presently illegal, exclusionary zoning, and many other conservative scholars would say that it is a taking. It's a taking in terms of, it's a taking without due process of law. The third form of public discrimination that's constant is discriminatory school boundary drawing. About a third of school boundaries that are drawn in racially diverse districts make segregation worse in the schools than it would be in the housing market. And under Keyes versus Denver School District, that's an illegal practice. It's a constant practice. It happens all the time. What are the private forms of discrimination? Mortgage lending discrimination, and this is very severe. In the Twin Cities, if you're a black family that earns $175,000 a year, you are less likely to qualify for a prime loan than a white household that earns $40,000 a year. That's data, that's federally produced data under the Home Mortgage Disclosure Act. Now, banks say it's because of credit histories, there's litigation about this, but that's not, it's never really panned out. There's no way systematically that a black household that earns $175,000 is systematically less creditworthy than a white household that earns $40,000 a year. And whenever that's been litigated, it's been settled, usually at significant rates. There's no good reason for this, and it's illegal presently at the moment. The other form of discrimination is steering, mortgage by real estate agents. Real estate agents show black and Latino people different neighborhoods than they show whites of similar education, income, and credit history. And I've looked at 150 steering studies, and steering is always present and glaring. So a black family that's moving out to the suburbs gets shown Brooklyn Park or Brooklyn Center, parts of Maple Grove. A similar white family that is asking exactly the same questions is shown Minnetonka or Plymouth or another neighborhood. That presently is an illegal act. So segregation, most social scientists would say there's no such thing as de facto segregation. There is only de jure segregation. That's the only kind of segregation that exists. Not everybody agrees, but I think most people do. Now, what happens in segregation? This web of discrimination is like a fishnet, and it traps within its boundaries poor black and Latino families, some poor Asian families. White poor families slip through this net. They slip through this spider web. They get to live in the nooks and crannies of affordable housing where it exists for a variety of reasons. But in this web of discrimination, black and Latino and Asian families get caught everywhere. And what happens when they get caught in this web of discrimination? It continues to sort. It sorts and sorts and sorts, and it creates what sociologists, what planners call neighborhoods of concentrated disadvantage. Neighborhoods of very troubled people. People that have long-term welfare dependency, families that have chronic illness, families that are deeply interconnected with the criminal justice system, families that just don't have the resources or had it for generations. Now, there are some white neighborhoods like this in Appalachia where you have concentrated disadvantage. And they have a hard time. Concentrated disadvantage, most sociologists, most planners know that concentrated disadvantage destroys educational opportunity, destroys health, and also contributes immensely to violent crime. And that's true not only in the poor, racially segregated neighborhoods of the Twin Cities, but in neighborhoods of concentrated white disadvantage in Appalachia. When you concentrate disadvantage, most social scientists say it destroys opportunity, it destroys health, and it is associated with high levels of violent crime. Now, the levels of violent crime that are produced by concentrated disadvantage don't affect white people very much. They are confined within the boundaries of concentrated disadvantage. So when we are creating this violent crime, we're allowing it to be created in Appalachia or in these segregated neighborhoods we're creating a world of immense disorder that is inflicted on the people that are left behind. And the immense disorder, which I'll talk about, has big effects on health. It transcends, it correlates to many other things, and we've been doing that. So I wanted to touch a couple of those things. Now, we also know a lot about what happens when people get out of neighborhoods like this, and we've known this for 50 years. But today, we know this more clearly and more thoroughly than we ever have before, in part because of scholars like Rucker Johnson, a path-breaking economist at Berkeley, and Roz Chetty, another path-breaking economist at Harvard that have been able to assemble huge data sets. What do we know about what happens to people in segregated neighborhoods, and what do we know about what happens when people get to escape those neighborhoods? We know that test scores and dropout rates accelerate dramatically in neighborhoods and schools of high disadvantage. They double. The scholar Robert Balfont at the University of Buffalo calls segregated high schools dropout factories that predictably produce half the kids are dropping out of high school. We know that the connection to college and post-secondary income in segregated schools drops off the charts. I'm going to show you some data locally about what happens. Every college in the United States grades every high school in the United States on its rigor. It gives it a grade. And when a child is admitted to college, that grade that its high school gets is as important or more important than their own individual grades or test scores. So it creates a huge disconnect. What happens when you live in poor neighborhoods? We know that from experiments in the Clinton administration, we knocked down subsidized housing and allowed people to move into less poor neighborhoods. We know that their income grows. Roz Chetty has said, if you take a look at these studies, he's used vast sets of income tax data. He's used data from the MTO project, the Moving to Opportunities project. People moving from a super high poverty neighborhood into an intermediate level poverty neighborhood gain $300,000 of additional income over their lifespan that he shows on a consistent basis. He shows that they're 20% less likely to be going to prison. They're dramatically more likely to be going to college. So that we know that there are these big data studies really show powerful effects of integration in many ways. Rucker Johnson, who has studied all of the school desegregation decisions in the South, and the South became the most integrated place in the United States. About half of all the kids went to integrated schools in the post-Brown period because of the action of the Johnson administration. He's shown that the lifetime earnings ratio of the kids that went to integrated schools was 30, their income over their lifetime was 30% higher than the kids that didn't go to integrated schools. The chance that they went to college more than doubled. He said the effect of going to an integrated school, this is an economist at Berkeley, was the equivalent of having 2 college-age parents. He compared the chance of going to integrated high school was the equivalent of having 2 college-educated parents. There was an 11% improvement in good and excellent health, and the kids that went to integrated schools, the disparity in between health in blacks and whites was cut in half across the entire South over 50 years. The chances of a young person going to prison in the integrated parts of the South were 22% lower across the entire South over a 50-year period. So there were big changes. Let's talk about local schools in the Twin Cities. I just want to, I'll come back to some of these, but this is a picture of our high schools in the Twin Cities metropolitan area. We have the top 30 high schools and the bottom 30 high schools. And these are high schools that are ranked, this is using a data set called SLEDS. And it's a comprehensive post-secondary census of what happens to kids after high school. And we looked at the top 30 high schools in terms of opportunity, many of which were racially integrated high schools, many of which were predominantly white high schools. In the top 30 high schools, 6.9% of the kids dropped out. And these schools include St. Paul Central and Minneapolis Southwest, among others. In the top 30 high schools, 15% had no post-secondary. 11% went to a 2-year for-profit college. 34% were in 4-year colleges, and 31% were in elite 4-year colleges. So if you look at the top 30 high schools, about 2/3 to 3/4 of the kids were in post-secondary. Only about 7 or 8% had no plans or were dropping out. The bottom 30 high schools, very much like the studies of Roz Chetty and Rucker Johnson, 46% of the people drop out. They never finish. These are the dropout factories that Robert Balfons talks about. Of the people that finish, an additional 30% had no post-secondary plans at all. Nothing post-secondary. So you have this, you have 3/4 of the kids either drop out or have no post-secondary plans. They're going nowhere. You have 15% go to two-year or for-profit colleges, and this is skewed toward less accredited for-profit colleges, colleges that don't necessarily have that payoff, and 8.7% in four-year colleges and 3.4. So you can see a difference. You have one set of schools that's a pathway to all the opportunity of the American society, and one set of schools is a pathway to nowhere. And we're creating these schools faster, 8 times faster than our racial counterparts, and we're building all the affordable housing in these places. You can see this is a map that shows the high opportunity high schools, which are the yellow high schools, and you can see many of them in western suburbs, but you also see schools like Minneapolis Southwest, St. Paul Central in that group, which are racially integrated high schools. Many of the suburban schools are racially integrated in this top group, and you can see the outlying areas. Now, in the bottom high schools, all of them are segregated schools, and half of them are charter schools. And in these schools, they're all segregated schools. They're all high poverty, above 90% schools, and they're all segregated. And many of these schools actually advertise themselves as pathways to college. They promise that everyone will go to college, and nobody really does. And this SLEDS data was a way to look through that. So you get a feel for some of these issues. Now, how did this happen? How did these things happen? Part of this was abandoning our civil rights laws, deciding that we no longer wanted to do some things. Now, initially in the Twin Cities, as Bill said, Earl R. Larson desegregated the Minneapolis public schools in 1971. And he found them guilty of intentional discrimination and ordered racial integration across those boundaries. I was fortunate to be a product of that forced desegregation. It happened right when I was going to junior high school. And I actually met Earl R. Larson when I was 13 years old. I was on the Student Desegregation Advisory Board. And it was a life-changing experience for me and many other people. Earl R. Larson allowed the school district to, he withdrew his jurisdiction over the case in 1983 in exchange for a promise that the state would keep all the schools integrated under an administrative rule called Rule 3535. So Minnesota implemented a Rule 3535 that required that every school be within 20 or 15 or 20 points of the mean of the school district's average. It was called a flexible racial ratio. And now when we get into this world, here's where we get into some kind of dicey things. One of the things that we need to talk about when we're talking about policies like racial integration, we have to talk about a case called Bakke and a case called the Harvard case. And people have to know a little bit about equal protection law. I know this is going to be a podcast, so I'm going to go over some of the basics of this so that it's a little bit more explicable. But we have an amendment to the Constitution called the Equal Protection Clause. It was passed in the wake of the Civil War. And it didn't have much meaning for a while, but in the 20th century, the courts decided to give meaning to the Equal Protection Clause. One of its most important cases was Brown versus Board of Education, in which the court said segregated education was inherently unequal. Now, for a long time, scholars, Justice Marshall, Justice Warren, liberal scholars believed that the Equal Protection Clause was a clause to end the subordination of black people, a clause that was designed to bring everyone up to the level of white people. This was Thurgood Marshall's understanding, certainly. This was William Brennan's understanding. But in 1973 or 4, there's a case called Bakke that comes in, and it changes the meaning of the Equal Protection Clause. It says, no, Justice Marshall, you're wrong. The Equal Protection Clause is not an anti-subordination clause. It's an anti-classification clause. The Equal Protection Clause is not a clause designed to remediate the condition of black people and other disadvantaged classes. It's a clause that prohibits racial classifications of any kind. Now, you can do racial classifications, said Justice Powell at that time. You could have statutes that involved race, but they had to serve what was called a compelling governmental interest and they had to be narrowly tailored. They had to be the only way to do it. So Bakke is a game changer. It changes the meaning of the Constitution. It says the Equal Protection Clause is mostly about not classifying on the basis of race because it's divisive. It's upsetting. It's particularly upsetting to whites. And not only are black people covered by the Equal Protection Clause, but white people are too, and they can lose out in things like affirmative action. So when we see this change in the way that the Equal Protection Clause works, we see attacks on affirmative action, and they culminate ultimately in the Harvard case decided a couple of years ago where this affirmative action is illegal. Now, some people have believed from the beginning that racial integration in schools and housing is the same thing as illegal affirmative action. They say that that's the same thing. It's the same thing, and it should be the same, it should be subjected to the same level of scrutiny. Now, the Supreme Court, at the time Minnesota created its desegregation rule, the Supreme Court thought that this was a good idea. And in a case that was decided in 1971, the court said, and it was North Carolina versus Board of Education versus Swan, it said, we observe today that school districts should have wide authority. State and local districts should have wide authority in formulating school policy. And as the matter of educational policy, authorities may well conclude that some kind of racial balance in the schools is desirable. It says even apart from any constitutional requirements. They sort of said, this is a good thing. If you want to be integrated, this is a good thing. Then Bakke came, and then people began to challenge this case. In 1978, people challenged Rule 3535 in Minnesota. They said, you know, the Rule 3535 is illegal affirmative action. And Judge Beck, the chief judge of the Court of Administrative Law, said, no, it's fine. This is different. Racial integration is different from affirmative action. It's good. And he cited Swan. He cited these cases. And he said it was illegal in 1970. He said it was legal and perfectly fine. And that was the position for a long time of the state of Minnesota. In 1999, in the middle of a gubernatorial election, suddenly the position of the state of Minnesota changed. And in an opinion that was issued in 1999, the Attorney General, writing on challenging a rule that was being promulgated by Arne Carlson, a liberal Republican governor, that would continue Rule 3535. Arne Carlson was strengthening this rule. They said, recent cases in the federal district courts and the United States Supreme Court call into serious question whether it is permissible to have a rule which requires or even encourages race-based student assignments, because such quotas and mandatory busing are illegal absent a finding of intentional discrimination. So suddenly, we have a ruling in the state that says voluntary integration is basically illegal or probably illegal. And so it's a very different position. Now, what is the Supreme Court saying? I mean, in some ways, the court was saying that they were anticipating. They were trying to anticipating and read the tea leaves of what the Supreme Court might do. But in 2007, the Supreme Court comes back and discusses this very subject again. And Justice Kennedy, writing for the Supreme Court and parents involved, the challenge very much to voluntary integration programs in Seattle and Washington. Justice Kennedy, writing for 5 justices, says, the nation has a moral and ethical obligation to fulfill its historical commitment to creating an integrated society that ensures equal opportunity for all its children. Justice Kennedy says a compelling governmental interest therefore exists in avoiding racial isolation. And a school district may, in its discretion, choose to pursue goals to end racial integration. He says, likewise, a district can consider it a compelling governmental interest to avoid the isolation of students in segregated schools. And he goes on, he says, executive and legislative branches, which for generations have considered these types of policies, should be permitted to employ them with candor and with confidence that a constitutional violation does not occur whenever a decision maker considers the impact of a given approach. So after this, 7 or 8 years after Minnesota says that these things are basically illegal, Justice Kennedy says, no, they're fine. They're good things. It's not the same, says Justice Kennedy. He said integration by geography, he lays out a whole bunch of ways to do this. He said you should try not to use race, you should try to use class, but it's legal. So in this process, George Beck, who had in 1978 upheld the Minnesota desegregation rule as a retired judge, went into administrative court, and he had the new rule that had been promulgated in 1999 thrown out. It was the first time a major rule had been thrown out of an administrative agency in 20 years. They reformulated the rule. Judge Poos threw it out the first time. 6 months later, Judge O'Reilly threw the rule out. And twice, this rule was thrown out by a state administrative law judge. It's the only rule of a major agency that has been thrown out, and then that was kind of the basis for the litigation that was begun. We have no rule, we have no particular issue, we have no particular law governing this, except we know that the rule that we made was wrong, that Arnie Carlson's rule that Skip Humphrey said was illegal was probably legal, and we're in a situation where a lot of things have happened. Now, besides saying integration was basically illegal, the rule also said that charter schools were exempt from any obligation to integrate. So there had never been a decision that exempted charter schools from a racial integration plan. There were lots of places that treated them as if they were exempt. There were a lot of places that didn't pay much attention, but no one had specifically exempted them and given them a green light to be integrated. It also exempted a pattern of interdistrict enrollment called open enrollment. And you can see charter schools on a segregated basis began to grow exponentially during this period. And as single race entities, as entities that almost always are a single race entity, either all black or all Latino or all Hmong or increasingly very white, particularly in racially diverse areas. So you can see here's charter schools in 2004 and 2005. In Minneapolis, in St. Paul, about 30,000 kids go to charter schools that are unregulated. In Portland, Oregon, 1,300 do. In Seattle, Washington, 4,000 do. We have 30,000. Portland, Oregon has 1,300. Seattle, Washington has 4,000. And this is a driving feature. And the public schools are pretty good at becoming segregated all by themselves, but the charter schools put pressure on the public schools. So they will come into a neighborhood and they'll say, a single race all black school is the way to go. Then the public schools will create a single race all black school to capture market share. In St. Paul, they'll say a single race all Hmong school is the way to go. So you'll have a charter school and then you'll have a public school that'll be a single race all Hmong school. Increasingly, some of the charters like Nova Classical Academy, which is one of the highest opportunity high schools, is a very white school. And it comes into the neighborhood and says, we have a special school that is really good and really high opportunity. It puts pressure on the public schools to create a school just like Nova Classical Academy. It puts pressure on the public schools to create a competitor for Nova Classical Academy. So the public schools are pretty good at doing it all by themselves, but the charters pick up steam at both ends, at every spectrum of the thing. And you can see this is the growth of the charter schools over this period of time. Now, if charter schools were integrated, like they are in some states, you wouldn't have quite as much of an effect. You can see the exploding population. And one of the things that's kind of interesting about charter schools as compared to public schools is Brown versus Board of Education is a complicated decision. It's got one of its simple outcomes is if you have black and white children that live in the same neighborhood, you don't by law send the black children to one school and the white children to another. That's the simplest holding of Brown. But in St. Paul, you can have black and white and Latino and Hmong kids who live on the same block, and the black kids will go to an all-black charter school, the white kids will go to an all-white charter school, the Hmong kids will go to an all-Hmong charter school, Latino kids. And is that the same thing as Brown? Is it the different? It's a complicated thing. The charter schools aren't the only option. They're not like the public schools, but in some ways, it stands on its head some of our understandings of how this might work. Now, these are charter schools. The fastest growing new type of charter schools are the predominantly white charter schools, which are popping up in all these racially diverse districts. And they are popping up, they're at least 20 points whiter than their local public schools. The first were the all black charter schools, second were the Latino and Hmong. Now the fastest growing sector is these very white charter schools that are growing up. Open enrollment I talked about. And this is a particular, open enrollment used to be regulated by Rule 3535. Another thing, the 1999 rule said all choice could happen. There were no rules about it. It used to be that districts had to cooperate with each other, make agreements with each other about open enrollment. That fell apart. And you see school districts like Minnetonka, which is a very affluent, very good school district. They draw huge white populations from all of the surrounding more racially diverse districts. Now, is there any intentionality in that? Nobody knows whether there is, but they don't seem to be drawing black and Latino kids from the increasingly diverse suburban districts around them. So you have this open enrollment pattern, which has a disparate impact. It tends to favor whites exiting, and particularly exiting racially diverse suburbs to new suburbs. You also have funny boundaries happening all the time. And a third thing that the new rule of 1999 did is it made it very hard to prove intentional discrimination. It made it harder than federal law. Under federal law, under Dayton versus Columbus and Brinkman, foreseeability was part of the determination of intentional discrimination. Our new law in 1999 said foreseeability can form no part in that determination. So Apple Valley drew a school boundary line that connected a trailer park. See that little blue area up there? That was a trailer park that was all Mexican kids. And that discontiguous line went across 2 white school attendance areas and connected up an area where they had apartment buildings where Somali families were living. You had another boundary, the Shannon Park boundary, where it connected 2 very white neighborhoods and skipped over a black neighborhood. And the school district, when that was challenged, they said they couldn't prove intentional discrimination in that case. So it shows that the rules became harder, and rules make a difference. One of the things I'd like to say to law students is rules do make a difference. So housing is the next piece of the puzzle. At about the same time we moved away from Rule 3535 and its very rigorous enrollment, we moved away from a very, I think, visionary region-wide fair housing plan, one that still is implemented in Portland, Oregon, and is still implemented in Seattle, Washington, our counterparts. And we all said that everybody should provide for their fair share of affordable housing. We all said that communities in their land use plans, zoning agreements, and development agreements had to follow the rules of ending exclusionary zoning, and our state housing finance agency awarded subsidized dollars in ways that would encourage the suburbs to do this. So for about 10 years, we were building 70% of all the subsidized housing in the whitest part of suburbia, like Portland, Oregon, like Seattle, Washington isn't quite that good, but pretty close. But we all used to do this. We stopped doing this, again, because of this idea that racial integration was not legal. It was like a voluntary affirmative action. And what we decided to do was we decided on a plan of enrichment. We were going to build very heavily subsidized housing in the poorest neighborhoods. We were going to go double down on that project because this was the way to turn people's lives around. And you can see this is a pattern of subsidized housing units in Minneapolis and St. Paul and how they encompass very poor neighborhoods. And one of the neighborhoods we've recently been studying is the Phillips neighborhood of southwest Minneapolis. In the Phillips neighborhood, 42% of all the people live in subsidized housing. It's the highest concentration of anywhere. In the last 15 years, we have spent, as a state and federal government, about $1 billion building affordable housing in the Phillips neighborhood. About $1 billion of state and federal money building units for 42% of all the households. We built them at a cost of about $500,000 per unit, which is it's a little bit less than twice as much as it costs to build the same unit in Dakota County. We build them for about $500,000 in Phillips. They rent in Phillips for about $1,200, which is a little bit more than the market rates rents are in Phillips. In Dakota County, where they build the unit for $290,000, they rent for $850. In Phillips, they cost $500,000, they rent for $1,200. We've built $1 billion, and that doesn't count for the philanthropic money that we've spent in doing this. That's just the state and federal government. Phillips, they promised that if we made this major investment, that we provided half of all the people with affordable housing, their education would get better, their health would get better, and crime would go down. What happened? Well, the schools disappeared in Phillips. There hardly are any elementary schools in Phillips. The schools that surround Phillips are the lowest performing schools in the state, or very close to the lowest performing schools that have the lowest test scores. In our college study, we're building all of these units in places where kids are going to drop out and not go to college. Phillips is one of the places where that happens the most, and the schools have not improved as they said they would. What's happened to health? We have really good data about health in the Twin Cities. And Phillips has become the least healthy, one of the least healthy neighborhoods in the Twin Cities. This is life expectancy by birth. It's one of the lowest. This is the percentage of children with elevated lead exposure, one of the worst places to live. Asthma, one of the highest rates of asthma. Chronic obsessive pulmonary disorders, one of the highest neighborhoods of chronic. Coronary heart disease among adults, one of the most dangerous places to live. Diagnosed diabetes among adults, one of the highest places to be. High blood pressure among adults, one of the highest places to be. Obesity among adults, one of the highest places to be. Stroke among adults, one of the highest places to be. Depression among adults, one of the highest places to be. Poor health, it goes on and on. The maps are on and on. What else happens in Phillips? They promised if we built $1 billion worth of new housing in Phillips for everybody, crime would go down. Well, crime is higher in Phillips than in any place in the metropolitan area. It used to be, I wrote a book in 1997 that talked about crime in the Twin Cities, and Phillips had high crime then, but North Minneapolis had higher crime. Phillips now has a higher crime rate than any place, and particularly violent crime. The kinds of things that social scientists said would happen when you concentrate social disadvantage. There's a powerful link in the social science literature between concentrated social disadvantage and violent crime. Phillips now has the highest rate of violent crime, which is a feedback loop in terms of people's health and well-being. It's a feedback loop in terms of whether they feel safe in community and can form organizations. So we spent $1 billion creating the worst schools, the worst neighborhoods in terms of health, and the highest crime rates. I wouldn't say that the housing caused that, but it didn't change the trajectory of what was happening in segregation. And we know that had those units been built in other places, that those families would have had big appreciable gains. They would have had $300,000 more in lifetime earnings. They would have had twice as high of a rate of graduating from high school or going to college. They wouldn't have been in this dropout cycle. It wouldn't have been utopia for them, but it would have been very different from them. We know that the young men would have been 22% less likely to be incarcerated and in jail if that happened. So this is one of the things we've done. And so these are the kinds of things that these cases are facing. They're looking at these big issues. What kind of a structure of law do we have to think about this? We have a Supreme Court that has suddenly taken on very big responsibilities and big changes. In Kahn versus Griffin, the Minnesota Supreme Court said it was going to feel free to use the federal rights as a baseline upon which they can expand on. In 2020, the Minnesota Supreme Court in Fletcher versus Minneapolis Properties declared that there's a disparate impact cause of action to enforce the Equal Protection Clause of the Minnesota Constitution. It's the only constitution in the United States where you don't have to prove intentional discrimination to enforce the guarantee of equal protection. In Cruz-Guzman, in 2023, the Supreme Court said that a claim of segregation is cognizable under the Minnesota Education Clause alone. The first time a court ever said that in the United States. You have state desegregation cases in Connecticut and New Jersey, and they're both based on segregation clauses in that Constitution. But in 2023, the Minnesota Supreme Court said a segregation cause of action is cognizable under the Equal Protection Clause alone. They also said the plaintiffs don't have to prove intentional discrimination. They don't have to prove disparate impact discrimination. All they have to show is that there is a relationship between segregation and educational inequality. And so that's what's happening right now in these cases. We have Cruz-Guzman with his very strong opinion by Justice Chudich, an even stronger opinion by the year before. You've got an expanding constitution. You've got a series of statutes that parallel the federal statutes but have never had been interpreted by law. The stair-step initiative, the bold initiative of Babington Johnson and the 150 churches that they're involved in has survived a motion to dismiss, but there's no case law on that. That's proceeding in the courts. How is the world changing? Can this happen? Will it be legal under the Supreme Courts if anything happens? One of the things that's happening is the suburbs are changing. When I was a young man in the Minnesota legislature, I authored a fair housing bill that was vetoed twice, finally passed and signed by Governor Carlson in 1995. And during that time, there were parts of the suburbs where I was literally burned in effigy, places like Eden Prairie and Minnetonka. By 2010, Eden Prairie drew the most integrated school boundaries of any school district in the region, and I helped them do this. It's changed. The suburbs have changed. This is the political map of the suburbs in 2000, and the blue is Democratic and the red is Republican. And you can see the central cities and the older suburbs are pretty blue. Watch what happens over time. This is 2002, 2003, 4, 5, 6, 7, 12, 14. You can see that many of these suburban communities that were once very conservative have become democratic, and they're willing to build affordable housing. Minnetonka is wanting to build affordable housing in the whitest, most powerful school district in the state, and they're being turned down on a regular basis. Edina is being turned down. Lakeville is being turned down. Many of these suburban communities that are willing to do it, at the time when I was a young man, didn't like me or it, are willing to do this, and we are systematically turning them down on a state basis when they're doing it. They're different. Who is the opponents now? Who are the opponents to these policies? It's really changed. The opponents, more than anyone else, if you look at the litigators, if you look at the parties, It is the people that run the charter school industry, which is $1 billion a year business with a business model that's based on racial segregation. They are engaged in the court, have very good lawyers, the same lawyers that when I was a young man working for the NAACP, worked for the state of Georgia and the state of Alabama, the same law firms that dismantled school desegregation that are working for the charter schools now. The people that build affordable housing, it's affordable housing, another $1 billion a year industry. And the people that build it become pretty wealthy. We did a study, we found people who were building affordable housing were building equities of tens of millions of dollars. Frontline, the PBS documentary, found people that were becoming billionaires using the low-income housing tax credit to build affordable housing, layering subsidies in neighborhoods. And they have become powerful proponents of this idea that, that a segregated, separate society is the way to go. Let's talk a little bit about law. One more time about housing. So the Obama Justice Department, quoting Walter Mondale in the rules that I worked on when I was a consultant there, the Obama administration declared, quoting Walter Mondale, the Fair Housing Act's language prohibiting discrimination in housing is broad and inclusive. The purpose of its reach is to replace segregated neighborhoods with truly integrated and balanced living patterns. The intent of Congress in passing the Fair Housing Act was broad and inclusive, to advance equal opportunity in housing and to achieve racial integration for the benefit of all the people of the United States. That's upheld by case law. So far, all the courts are in coherence with that statement. The Trump administration has a different position. So do the affordable housing developers. Their position in court is what we quote, the word integration never appears in the law. The text of the Fair Housing Act and the congressional record bears out the contention that integration has been read into the acts improperly by the courts. The words integration and segregation, for example, never appear in Title VI, nor is there any direct statement of policy or intent showing that Congress intended to achieve racial integration. So you have very clear differences. Is integration affirmative action? Right now, at this moment in the United States today, it's not. Justice Kennedy's opinions rule. It may be tomorrow that it's not, it is different. Although recently, the Supreme Court denied cert in the Boston desegregation case last December. Boston was integrating by neighborhoods and by test scores in neighborhoods to create an integrated plan, to use a race-neutral collection of data to create a racial integration plan. The Second Circuit upheld this plan under parents involved, and the Supreme Court denied cert. There were two pretty tough dissents from the denial of cert by Justice Alito and Justice Thomas. And they suggest that, maybe very soon, racial integration will be a legal affirmative action. But at least at this day, at this moment, at this time, it's legal. And in fact, there's opinions of the United States Supreme Court say that it's good. The state of Minnesota says it's illegal at the moment, or it's probably illegal. The Federal Fair Housing Act, Justice Kennedy, writing in 2015, says under the Federal Fair Housing Act, Walter Mondale and President Obama were right. The Fair Housing Act requires integration. That's the law today. That's the Supreme Court. That's all the federal courts. No federal court has held otherwise yet. That may change. But today, that's the law, and we can do these things, and we should be doing these things, in my opinion. These cases, Stair Step and Cruz Guzman, create this challenge. Can we create more integrated schools in the state courts in the face of a hostile federal judiciary? Is it possible? Is it possible for the states in a federal system to make these guarantees stronger? I think the answer is yes. I think we can do that. I think that there's a pathway through that. We'll have to see. It's certainly not a clearly defined, but it's a huge challenge. We know in some ways what Justice Roberts was saying in the Harvard case, what others were saying, was all this diversity stuff, it's not very tight fit. It's kind of nebulous. All these ideas are sort of nebulous. But integration is not nebulous. It has a very tight fit. In fact, there's nothing else that's ever worked as consistently or as effectively at reducing educational disparities in the country. Spending hasn't done it. Charter schools haven't done it. Nothing else has done it. If he wants a tight fit, there's a tight fit here. Is integration a compelling governmental interest? At the moment, it is. But if you look at this data, it has to be. If kids in poor neighborhoods are consigned to dropping out and not being part of the American society, if they're going to earn less, if they're going to go to prison, if they're going to be less healthy, what is more of a compelling governmental interest than that? Is it narrowly tailored? We don't know anything that works this well. There's other things we've tried, but nothing works consistently. Integration is not a panacea, but it produces results every time, every place, all the time. So I'm getting the signals that I've talked too long. And that's the problem you have when you have a law professor that used to be a state senator. But I thank you for the experience. I'm grateful for this chair. It's been the greatest honor that I've ever had in my life. And I stand ready for questions, and I hope there's some hard ones. So thank you.
There's microphones. I think we're only going to take about 2 or so questions because there's food awaiting us, but I'd welcome a couple of questions. And Olivia has a microphone, and Jeff has a microphone. So who wants to ask? Here we are.
Yes, Professor, you laid out this quite eloquently, and the question with the state, these cases being brought in the state, where there might be a little better receptivity, but there's looming the federal government and the Supreme Court and the evolution they may be taking. What's your prognosis of that dynamic and the viability from it?
Well, I think, this has been, the state of Connecticut has tried to integrate their schools under the state constitution of Connecticut. And they were challenged by the Heritage Foundation and other conservative legal groups. And they were saying that Connecticut, interpreting the Connecticut Constitution and the race-conscious remedy the Connecticut Constitution issued under their own court was illegal. Connecticut decided to restructure their plan, kind of the way Boston did. They used socioeconomic factors. They had a race-conscious outcome, but they used things like neighborhoods and poverty rates. They used algorithms to try to restructure this to achieve a race-conscious outcome with a race-neutral criteria. This is what Boston did. And so that suit settled, and it seemed to me that the parties accepted that. Recently, last December, the US Supreme Court denied cert on a plan like this in Boston. So, but Justice Alito wasn't happy about it. Justice Kennedy wasn't happy about it. Justice Gorsuch said he might not be happy about this in the future. He can't decide. So this is the question. But, if we can't use race, we can use neighborhoods. Neighborhoods are race neutral. We can use socioeconomic statistics. In 2003, Wake County, North Carolina, operated a racially integrated school district plan, and they changed it to socioeconomic status and neighborhoods, and the Bush administration, in a letter from the Office of Civil Rights, said that was legal. So, I mean, if you look at Justice Alito, Justice Thomas, they may not have any patience for that, but at least so far, the courts have accepted that. The Second Circuit has accepted that. The Bush administration has accepted it. If we don't have that, we're going to have a level of apartheid in the country that makes Plessy versus Ferguson seem silly. Plessy versus Ferguson didn't forbid integration. It just said it wasn't required by the Equal Protection Clause. It said separate but equal was not enough. If we go to the place that Justice Thomas and Justice Alito have, Plessy versus Ferguson will seem tame.
Myron, could you just run through if there's been any pursuit of some kind of remedy through lawmaking, through statute?
There's been an effort to settle this case in the legislature, but there hasn't been much progress on this. I think the parties would like to settle. Keith Ellison is the defendant in this case, but the legislature hasn't taken up that challenge. I think it could be very beneficial for the existing suburban jurisdictions to settle this case. We have now built 150 new schools at the outlying edge of the metropolitan area in areas that are basically exurban in the last 2 decades. We built 150 new school buildings as a state to facilitate people moving beyond the metropolitan area. And we're closing schools not only in the central cities, but in these older suburbs. A really good plan could rebuild not only the central city schools, but the first-ring suburbs too. So I think they should, but they certainly haven't taken it up yet.
There will be more opportunities to corner Myron over canapes or whatever delightful treats we have upstairs for our refreshments. So I would ask you again to thank and congratulate Myron Orfield as the Earl R. Larson Civil Rights and Civil Liberties Professor of Law.